let's talk about presumption of paternity. This is a little known idea of law that actually prevents people from challenging the biological status of a child of an intact marriage. Where we see this at most issue is honestly the potential children of affairs. And so, in a case that came down recently from Pennsylvania Superior Court, a father brought a case in the underlying court seeking genetic testing of a child that he believed was his. And the courts, after hearing 3 days of testimony, did allow for that genetic testing. The mother and her husband brought that case up on appeal. So let's get into the facts. So the facts of the case are that the parties were married in 2009. They had one child together, and then sometime in 2016, they were having trouble. They had had a number of unsuccessful pregnancies, and they decided to actually separate in terms of moving out of the shared marital residence. They obtained an apartment where they would leave the child of their marriage in the marital home, and they would go back and forth between the apartment. Now, this was in about September of 2016. In February or March of 2017, mother attended a wedding where she met father. So again, this is our parties that we're talking about today are the husband, the mother, the husband, the wife, and the father. Now, after the marriage, after the wedding, the parties then began to have an affair. And a few months in, wife finds out that she's pregnant. She decides to have prenatal testing, having both the father and the husband tested. And since we're calling the father, you should be able to guess what the results are. The father is the biological father of her child that she's still carrying. During this time, she's kind of still going through counseling with the husband to try to work on the marriage. They have not filed for divorce at the time. And she's still seeing the father and not the husband as well. So the father's preparing for the birth. They're talking about names. He's visiting her. He sees her other child with him. They're on social media. They go on trips. And he introduces her to his family, all the while preparing for them to be together and welcome this new child. Sometime in November of 2017, wife goes on a trip with her husband to New Orleans, and that's where they allegedly rekindle their relationship. She decides, or according to husband, that they're going to get back together. However, she's still seeing father, and her affair with father continues until about the time the child is born, which is March of the next year. During that time, she moves out of that separate apartment. The father helps her move out. He even meets husband, shakes his hand, and helps her move her things into her new apartment, which he understands is going to be for her to establish a place on her own. Now, the child is born in March. The father is across the state at a conference. The husband is there and is with her when she delivers the baby. The father does come, and the father spends at least one overnight with her in the hospital and is there with her at the hospital. The father gives the child his surname as one of its names, but the husband is listed as the father on the birth certificate. Now, after the actual birth of the child, the father attends some postnatal visits with the mother, so with the child's doctor's appointments, spends more time with mother. The husband actually sends out birth announcements stating this is their child. The child, again, has his full last name, and again, he's listed on the birth certificate. Now, a few weeks into this, mother decides she's going to get back with the husband, and she's going to basically try to work on her marriage for the sake of her older child. She tells the father this and tells him that he can no longer have any contact with the child, and that if he wants to see his child, he needs to take her to court. So that's what he does. So those are the facts of the case. All of a little bit more interesting than that, we're going to dig into a few more as we continue to talk about some of the legal issues in the case. So in March of 2018, father brings a claim for genetic testing in court. He's asking for the court to do his own DNA testing to prove that he is the biological father of the child, which gives some proper standing to ask for custodial rights, physical and or legal. And so he gets a response from wife and her husband that he is precluded from asking for genetic testing because of a presumption of paternity. A presumption of paternity in this particular instant means that there is a presumption that the husband of an intact marriage is the father of a child that is conceived or born during that marriage. So think of it like this. The idea is that somebody should not just be able to come into a marriage and say, hey, that child is mine, that child is mine. The idea, again, is to make sure that we're protecting families, protecting marriages. And so the court must establish whether or not the presumption of paternity applies in this situation, whether it has been rebutted, and then whether there is estoppel. Estoppel prevents someone from basically changing their actions after they've already held out a child to be theirs or to not be theirs. And in this situation, you're kind of protecting the child. So this is sometimes a situation we see where a child has known a father to be their father their whole lives, and they can become the legal father even if they're not the biological father. But we're not going to talk about that as much today because this case kind of stops with the presumption of paternity issue. So the question really for the court is whether or not there was an intact marriage in this situation. So the court held testimony for 3 days to talk to a variety of people and review an exorbitant amount of evidence to determine whether or not this marriage was intact. Now, the trial court did find that the marriage was not intact and then ordered genetic testing. So I'm going to bring us up to speed a little bit because the reason we're here is because this has been appealed. And this was appealed by the wife, mother, and her husband, basically stating that the trial court erred in not applying the the presumption of paternity in their case, and that there was significant evidence to prove that the presumption should have been applied. Now, in this situation, we know there's a deference to the trial court in terms of what the facts were and an assessment of credibility. And the appellate court looked at the fact that there was 3 days of testimony that was provided and looked at basically what happened. What's also interesting in the situation is that they also looked at the fact that whether or not the marriage was intact and the amount of harm that would be done to the marriage by allowing this father to come in. But let's take a step back. So what the appellants argue, so again, wife and her husband argue, was that their marriage was intact because they had not filed for divorce. They were still filing their tax return jointly. They had joint bank accounts. They were going to counseling. And father never changed his Facebook status. That's actually something that was listed to indicate that he was separated or no longer married to wife. But the court also needed to look at the actions of mother, right? You know, she's telling this other gentleman that she's separated. She's mentioning that she's getting a divorce. He knows her to be living alone. He helps her move out of this other apartment that she was sharing with husband and into another apartment. So, you know, he's going on trips with her. He's meeting her daughter. He's introducing her to his family. These are things to suggest that maybe the family is not an intact family. And then you look at what point of time are we going to look at? You know, are we looking at it from the time where the child was conceived or born, or when now this thing is filed? The court also had testimony from mother in a variety of ways in terms of text messages, because she continued to text the father and basically say that the reason I'm doing this is because I thought I would lose custody. Some attorneys told me that I might have a better shot at keeping custody if I went under it this way. And then she's also actually still sending some pictures to the father during this time as well. But that's neither here nor there. So the appellate court looked at, again, whether or not the presumption of paternity should apply in a situation, because was it an intact marriage? And the court looked at 2 cases. One was a case where it was somewhat similar to this situation, where wife basically had been having an affair, and it seemed like the parties had separated. Now, there was a filing for divorce in this situation, although they were going back and forth and a child was born. Basically, the court said that now that the parties have decided to get back together, the husband and wife had decided to get back together, it doesn't mean that this now father should not have rights to this child. This child should not know their biological father. The idea of presumption of paternity is not to make things more convenient for people, but it is to keep a family intact. And if people are now going through an affair, the husband now knows about the affair and chooses to stay, and in that type of situation, there's full knowledge of it. There's no reason for the court to apply the presumption of paternity in a place where the parties all know what's going on and decide to continue. They use the terms, it's water under the bridge. Now they distinguish that from another case where basically father had no idea about the affair, continue, throughout the pregnancy, raised the child as his own, held the child as his own. And now, this comes back a little bit later. So in that situation, the court says, no, there is a presumption of paternity in this situation. And so the court kind of used those two cases to distinguish what should happen in this instant case. And the court found it more like the previous one. So in those situations, the court found that, again, looking at everything that's going on, the fact that the husband was aware of it, decided to stay together despite everything that's been happening, suggests that there's no need to protect this marriage. Again, it's not about making things more convenient for the parties involved. Yes, it would be a lot easier probably for husband and wife to work on their marriage if they didn't have this other gentleman coming in and having custodial rights to this other child. They could pretend like nothing happened and just move forward. But again, that's not the point of the courts, and the court has to look at all the parties involved in this situation. So the court found that there was no need to apply the presumption of paternity in this case, and the genetic testing was affirmed, and we'll see what happens as the case continues. So if you have any questions, if you thought this case was interesting, let me know. Show me some love in the comments. If you've had anything like that happen, you want to talk about it in the comments, go right ahead. Again, this is not legal advice. The idea is to just present some interesting cases that are coming down in our state and just to discuss them. And I'll, of course, give you guys some idea sometimes of little known ideas of law that can actually impact your case. Until next time, take care.